Hey you guys, my name is Karsten Oosting, and this week I'm the lucky guy who is going to talk to you about question 1. The question is if allowing certain restrictions in online distribution is justifiable. To explain my statement, I will discuss the Pierre Fabre case. Because what is considered a selective distribution agreement now is anti-competitive. To determine this, the court will consider the wording and intent behind the contractual clause and will also examine the economic and legal context of the agreement. However, selective distribution agreements are agreements affecting competition by definition, since they usually provide for restrictions on distributors. When a selective distribution results in legitimate aims, it may be admitted does not fall under the prohibition of Article 101, Paragraph 1 TFEU. This is the case provided that 1. Distributors are chosen on the basis of objective criteria of a qualitative nature, which are laid down uniformly for all potential resellers and applied without discrimination. 2. The properties of the product concerned to make such a distribution is necessary in order to preserve its quality and ensure its proper use. And 3. The criteria laid down must not go beyond what is necessary. In the case Fabre is no discussion about the first point. The selection criteria for distributors were in each case objectively. The second point, however, is under fire. The question is whether it is really necessary to impose on the sale of body care products professional advice from a pharmacist. The court referred to this fact earlier case where it argued that non-prescription medicines and contact lenses do not need such professional advice to an incorrect use of the product counter. Fabre shouted that the distribution method imposed by it is necessary to preserve its prestigious image. This, however, has no reason to restrict competition. It is therefore concluded that the provision in fact have the effect to prohibit internet sales, a restrictive provision, and therefore falls under the prohibition of Article 101 TFEU 1. The second step is to examine whether the contested provision may benefit from the block exemption for vertical agreements, and in other words be permitted. In principle, only companies with a market share of less than 30% qualify for this exemption. However, the block exemption excludes certain types of all restrictions of competition, which is a serious anti-competitive character, also called hardcore restrictions. Thus, the block exemption in Article 4 sub c that does not apply to vertical agreements, which a direct or indirect restriction of active or passive sales to end users result by retailers. The old regulation on block exemption for vertical agreements does not state explicitly that internet sales are usually passive sales. The court ruled in any case that the provision indeed leads to limit passive sales by end users over the internet. Fabre also not qualified for the exemption. The court clarified that a selective distribution system may be provided, that a seller may not sell out his business or from an unauthorized place, but that the sale should not be construed as sales outside the company, via internet in this case. The court finally is very briefly on the third step and is limited by saying that Fabre still be eligible for an individual exemption if they provide the condition in Article 101 TFEU comply. For this purpose, the court did not have sufficient information. This, in a nutshell, should mean that the ban on internet sales has technical or economic benefits. A fair share of the added value benefits to the users. The ban does not go beyond what is necessary, and no less drastic measure for hands to achieve the same goal. There is sufficient competition in the market. By explaining this case, I hope you can develop your own opinion about whether certain restriction must be allowed in online distribution. Have a great day.